De facto corporation versus corporation by estoppel. A de facto corporation is one that is organized with tolerable compliance with the requirements of incorporation under the law and allowed to exist and exercise the powers of a corporation until its corporate existence is assailed by the state in a quo warranto proceeding. A de facto corporation has all the powers and authority of a de jure corporation until it is ousted of its corporate existence. Its existence cannot be assailed collaterally in a private suit, but only in a quo warranto proceeding. Thus, if a collection suit is initiated by a de facto corporation, a motion to dismiss filed on the ground that the corporation has no power to sue should not prosper. A de facto corporation, like a de jure corporation, may sue. The existence of such de facto corporation cannot be questioned in a collateral proceeding like a collection suit. A de facto corporation has the following elements. Number 1, existence of a valid law under which it may be incorporated. Number 2, attempt in good faith to incorporate. And number 3, actual use or exercise in good faith of corporate powers. As such, if the law under which it is incorporated is declared unconstitutional, there is neither de jure or de facto existence. For instance, if Congress enacts a law to create a private corporation, such corporation cannot be considered de facto because the law creating it is unconstitutional. With regard to the second element, attempt in good faith to incorporate, at the very least, means obtaining a certificate of incorporation from the SEC. The execution of the articles of incorporation and adoption of bylaws, per se, are not enough to warrant de facto existence. In other words, there is no bona fide attempt to incorporate until the SEC, at the very least, issues the certificate of incorporation. The filing of articles of incorporation and the issuance of a certificate of incorporation are essential for the existence of a de facto corporation. In fine, it is the act of registration with the SEC through the issuance of a certificate of incorporation that marks the beginning of an entity's corporate existence. This was based in the case of Missionary Sisters of Our Lady of Fatima versus Alzona et al., GR number 224307, August 6, 2018. Now, what is a corporation by estoppel? A corporation by estoppel is one that exists when two or more persons assume to act as a corporation, knowing it to be without authority to do so. In the case of People versus Garcia, GR number 117010, April 18, 1997, the Supreme Court held that the liabilities under the doctrine of corporation by estoppel is as general partners. All persons who assume to act as a corporation knowing it to be without authority to do so shall be liable as general partners for all debts, liabilities, and damages incurred or arising as a result thereof. Provided, however, that when any such ostensible corporation is sued on any transaction entered by it as a corporation or on any tort committed by it as such, it shall not be allowed to use its lack of corporate personality as a defense. Anyone who assumes an obligation to an ostensible corporation as such cannot resist performance thereof on the ground that it was or there was, in fact, no corporation.